Good evening, everyone, and welcome to our first Legal Network event of 2021. I am not a cat, I'm Josh Glukoft, and I'm a member of the Legal Network Committee. The Federation has 6 professional networks which have put together another great year of programming to bring together business professionals and to support the Jewish community. All 6 of the Federation's professional networks offer a variety of programming, some of which is networking-oriented and some of which is content-driven. I'd like to highlight, though, the Federation's new monthly networking sessions for business leaders from all of the networks. Those sessions are held on the 4th Tuesday of each month, and they use breakout rooms to allow for more informal conversation. We'll send you information about those sessions, and we hope you can join for the next one on April 27th. And to learn more about the 6 professional networks generally, you can head to the link in the chat of this session. I'd like to recognize the Federation for addressing some of our community's most significant challenges. In response to the pandemic, the Federation quickly sprang into action to help our community through a series of large-scale strategic efforts to care for those most in need, support families in staying connected to Jewish life, and to secure our community institutions. There's never been a more important time for the community to come together around the work of our Federation. Now I'll hand it over to Elisa Finston, SVP of the Federation's Community Engagement Strategic Initiative, to share more about the Federation's advocacy work.
Great. Thank you so much, Josh. It's nice to see everyone. I hope that people had a wonderful Passover, and it's good to be here with you tonight. So we wear multiple hats in the Community Engagement Strategic Initiative, and tonight I want to talk to you about the role we have in advocacy, as Josh said. So one of the things that we do is we advocate on issues of importance to the Jewish community. We do this primarily at the state level, but we also do this through JFNA, the Jewish Federations of North America in Washington, D.C. But tonight I want to talk to you about our state portion of advocacy. The Federation is the largest member in something called JPAC, the Jewish Public Affairs Committee of California, which is a membership organization of about 25 Jewish organizations from San Diego through Northern California, comprised of other federations, JCRCs, local chapters of JFS LA, JFS Jewish Family Service in the Bay Area, Hadassah, local chapters of the ADL and the AJC, Bet Tzedek, the Museum of the Holocaust, other organizations like that. And we advocate on many topics, but our priorities focus on ensuring the safety and the security of the Jewish community, ensuring older adults age with dignity and with an enhanced quality of life, including Holocaust survivors, sustaining services and programs to assist our most vulnerable populations, maintaining a strong Israel-California relationship, and combating hate and anti-Semitism. And we work in very close partnership with the California Legislative Jewish Caucus. And this year is the chair of the caucus is our very own Jesse Gabriel, who was on the board of the Federation, the community engagement chair, and an alum of our Rautenberg New Leaders Project. The previous chair was Senator Ben Allen, also an alum of the NLP program. And I know there are several alums on this event tonight, so it's nice to see you all. And so it's important for us to have allies as lawmakers who understand the Federation and the needs of the Jewish community. And we've had many successes, advocacy successes through JPAC that have directly impacted the LA Jewish community, where the Federation has played a significant role, including the funding for summer camps that were devastated by the 2018 Woolsey fire, funding for nonprofit security grants that go to our synagogue partners and other Jewish institutions, and funding for in-home support for Holocaust survivors. And many of you have likely heard over the last 18 months about the ethnic studies model curriculum that our Federation and JPAC also was involved in working on. And while we were mostly working with the California Department of Education on this, the curriculum was actually written because of a bill that passed in 2016 in the state assembly. So each year, JPAC does an annual advocacy day where before COVID, we would literally fly up to Sacramento and spend the day hearing from lawmakers and then walk over to the Capitol as Jewish community and lobby on JPAC's annual agenda where we pick specific bills and budget items to advocate on. So this year, we'll be doing the program virtually, and I'd like to invite you to join us. We are still finalizing the dates and the times and the advocacy items, but it will definitely be sometime during the week of May 10th. And there'll be a portion dedicated to small group meetings with legislators. So I'll make sure that Leah has the information to share with you when it comes out, because we'd love for you to be able to participate with us. Now I'd like to introduce tonight's moderator, Mari Henderson, who will introduce our panelists and get our discussion started. Mari is an associate in Quinn Emanuel's LA office. She rejoined the firm in 2020. With a background as a criminal prosecutor and on-air news reporter, Mari represents companies and individuals in high-stake litigation and advises clients navigating both the court of law and the court of public opinion.
Thank you, Elisa. I would like to introduce the three panelists who will be joining me tonight. I think we have a very interesting discussion ahead of us. First is Michael Friedman. Michael Friedman, who actually went to high school with me, is a criminal defense attorney and a partner at Worksman, Jackson, and Quinn. He is a former federal prosecutor and an experienced trial attorney who represents individuals and companies against all types of criminal charges and government investigations, and in high stakes civil litigation and appeals. He represents clients in state and in federal court and has particular expertise in white collar fraud, healthcare matters, the cannabis industry, money laundering, environmental regulation, and asset forfeiture proceedings. Next, we have Lori Levinson, who is the law professor my husband was lucky enough to have in law school, but I was not lucky enough to have her. She is a professor of law and chair in ethical advocacy at Loyola Law School. She is also the founder of Loyola's Project for the Innocent. Professor Levinson teaches criminal law, criminal procedure, ethics, trial advocacy, and evidence, and has authored numerous books and articles on criminal law. Professor Levinson served for 8 years as a federal prosecutor in Los Angeles and as Associate Dean of Loyola Law School from 1986 to 1989. Professor Levinson regularly provides commentary for high-profile individuals and trials and legal matters. Lastly, we have Eric Siddall, who is Vice President of the Los Angeles Association of Deputy District Attorneys. He himself is a Los Angeles County Deputy District Attorney. He is also designated as assigned as a Special Assistant U.S. Attorney for the Central District of California. At the DA, he is currently assigned to the CAPOS, or the Crimes Against Peace Officers Division. His past assignments include prosecuting gang homicides, domestic violence, and sex crimes, including crimes against children. He has tried over 80 jury trials and has written extensively on California criminal justice issues. So thank you all for joining me tonight. To kick off the conversation, we're going to be talking about 3 or 4 different pieces of new legislation in California that are going to impact the criminal justice system broadly. So I thought it would be interesting to have both a criminal defense attorney, prosecutor, and an esteemed professor and founder of an Innocence Project to talk about these legislative reforms and what we expect will happen in the years to come in California. First, we're going to be discussing Assembly Bill 1506. Under this bill, state prosecutors in California are now tasked with investigating police shootings that result in the death of an unarmed civilian.
Exactly the button.
Fatal shootings.
I knew you give them one.
But don't do it again.
I'm going to unmute. I don't know where that sound is coming from. It's not coming from my end. So I'm just going to keep going. Sorry for the tech issues. Under Assembly Bill 1506, state prosecutors in California are now tasked with investigating all police shootings that result in the death of an unarmed civilian. Fatal shootings by police are generally investigated by local prosecutors, DAs, but under this new law, the responsibility would fall under the state attorney general's office, which will have to publish a public report on each investigation. So Lori, first I want to ask you, the assembly member who authored this piece of legislation said that there's an inherent conflict of interest in police policing themselves, and that conflict of interest extends to local district attorneys who would be prosecuting officer-involved shootings and who do prosecute officer-involved shootings because they work hand in hand with local law enforcement to get elected to do their job. So I want to ask if you agree with that analysis And if you think that local prosecutors are too close to police officers to be able to independently evaluate these cases.
Thank you, Mari, and I want to thank you for putting this whole program together along with Leah and everybody else. It's just great to be with everyone on the panel and everybody who's tuning in today. So my answer is yes, there very much can be a conflict, but I think we have to be quite careful because we have district attorneys' offices throughout California, and they don't all operate the same way. And they don't all have special units that may be designated to investigate these cases with independent investigators. So if you don't have that situation, you very much have a conflict. They have the police investigate themselves and also prosecutors who work on a daily basis with them. I have a question about whether this remedy is the right direction to go. I'm not at all clear that the people, good people who work in the state attorney general's office have the expertise, have the investigators to do these types of cases. And for my era, we've got a great office across the street. Eric is involved as a special assistant. It would be the feds who are actually quite good using the FBI to come in and investigate these cases. So I do think that it's something where it's probably a good idea to have reports, to have more transparency, to have a system for those offices that don't have specialized units. But Eric might be able to tell you better whether there's enough independence in the district attorney's special units to actually do the investigations. And one last thing I want to add. I think this rule is designed to increase public confidence. Even if you would say, hey, we're independent, we can deal with this, the perception has been no, because there haven't been a lot of cases prosecuted. And that's why people took to the streets last year. You know, when I look at them, I try to explain, as you do on air, Mari, why in fact you have to be careful and you just can't charge every case. But the public is cynical right now about the investigation and prosecution of law enforcement.
Yes, and we're seeing that play out right now in the Derek Chauvin trial that I'm sure everyone is watching very closely. Now, Eric, I want to pick up on a couple things that Lori said, and I want to ask you about something that the DA's office here in Los Angeles is doing. There's been the appointment of a former federal prosecutor, Lawrence Middleton, to a 4-year term as a special prosecutor to assist in investigations of alleged police misconduct. So I want to ask, moving forward, with that in mind and this new initiative, how will that impact prosecutions of officer-related shootings?
Well, just as a starter, just so everyone's clear, I'm not representing Mr. Gascon's administration when I'm speaking. I'm really speaking as the vice president of the Association of Deputy District Attorneys. I think that one thing that is clear is that certain offices our office has about 850 line prosecutors. So we have a unit and a division that's very separate and apart from the other prosecutors in the office, and that they are able to, I think, independently investigate these types of crimes. The other DA's offices, some of them will have 3 DAs. So I'm not sure how they're supposed to be able to do their job as prosecuting cases, working with the police, and then also, prosecuting police officers for misconduct. Our office has had a long, successful history of prosecuting police officers. In fact, other DA offices around the state have asked us for assistance. I think in terms of Middleton, Middleton is is a very respected prosecutor. I think it was a very smart political move by the district attorney to have him appointed and give him a $1.5 million contract to review prior cases, because I think it takes the political pressure off of him. The bill itself, I think, also takes pressure out of a lot of prosecutors. District attorneys have been roundly criticized, including the current DA when he was up in San Francisco, for not prosecuting these types of cases. So, in fact, the Mario Woods shooting, which is the one that led, some of the mass protests that you saw in professional sports, that started because of DA Gascon's failure to prosecute the Mario Woods shooting. So I think this move, along with the Middleton move, it's a very good political move to get rid of the issue, which is a political hot potato for most prosecutors, of whether and when they should be prosecuting police officers. Plus, I think, as was mentioned before, these are very difficult cases to prosecute, and the public demands prosecutions, even if they don't understand the difficulty of these types of prosecutions.
Laurie, if I can jump in, and this is not to anybody's fault on this Zoom, you know, there is reason for the public to be just doubting. And maybe I'm just the old one on this group, but there was a case called Rodney King, and that was initially prosecuted by the DA's office. And for reasons that I'm not blaming the individual prosecutor, it did not end up so well. And the feds came in. And I think that's very fresh, even after 25 years in the public's memory. So, you know, I think the idea of saying to the public that there will be more accountability, again, my concern is just giving it to another office. If they don't have the expertise and if they don't have the resources, I'm not sure we'll just maybe increase the cynicism. But the transparency is a really good idea.
Well, Lori, I just want to jump off of something you said, talking about the feds coming in and maybe being in a better position sometimes. Would double jeopardy be at risk if federal prosecutors are working at the same time as DAs on these types of cases?
Well, you know, in California, under the law, although there was a challenge up to the Supreme Court recently, the feds have a separate sovereign and they can go after the state and there won't be double jeopardy. But if the state were trying to go after the feds, they might try to raise under the California Constitution double jeopardy. And if you actually had the feds just hand in hand, you're going to get an argument that they're not acting as separate sovereigns. So it does sort of confuse it a little bit. And I think that's why you have to keep them separate, just to preserve that opportunity to have that safety net, to have the feds come in and deal with the cases.
So just on that, there is a California statute that says if the feds do prosecute and in their indictment, the same type of facts and circumstances are in the indictment, then that would preclude us from prosecuting. That's a state statute.
So we'll have to see moving forward kind of whether there are more federal prosecutions of these types of cases.
Right. And, you know, in some ways, Lawrence Middleton, he has his work cut out for him, but we should also not forget that there's some additional resources that are helping. You know, at the time of King, we didn't have the police commission and the way we have it now. We certainly didn't have the oversight commission for the sheriffs. So I don't think any one approach, I don't think any one new rule is going to address this issue. I think it has to be done throughout the system, and probably is no surprise to anybody on this Zoom. We have a very, quote, independent sheriff. And if I were to address some of the issues, that probably would be the focus.
Well, Michael, I want to ask you about one of the limitations of this particular law and why, you know, Lori talking about the fact that it should be multiple different types of approaches. This law only applies to shooting deaths, so not other fatalities involving officers. And as we all know, some of the most recent and controversial killings have not involved officers firing a gun. George Floyd, Eric Garner. So do you think that this law goes far enough, or do you think that all police use of force incidents that result in the death of civilians should be investigated by the California Attorney General's office?
Sure. Thanks. First of all, thank you for having me tonight, and thank you for all the audience members who have joined us. I have an interesting perspective on this that I think is sort of informed by having been a prosecutor and now being a defense lawyer. And I think everyone on this panel would agree that both prosecuting and defending cases involving law enforcement as defendants are some of the trickiest, because a lot of the usual roles are reversed and it can often be topsy-turvy. And I think politically, I think there's obviously a demand, as Lori's mentioned, for this kind of attorney general approach, and I'm sure that there's a political demand for it to go further to the broader types of cases that you're referencing, Maury. What I think is interesting, and I would say concerning as a defense lawyer, is any kind of investigation, when you add jurisdictions that have authority over those investigations, it's concerning, and it is especially concerning when the lines of authority aren't clear. And so I can speak from personal experience that law enforcement is very worried these days about becoming defendants in criminal investigations. And as a criminal defense lawyer, one of my most important jobs is to keep it from going anywhere beyond an investigation. And so when you and Lori were talking about double jeopardy, I can tell you from personal experience, it's not just about a charge has been filed by one sovereign and then the AG or the DA is going to come along and charge as well. A lot of times, if I've done my job successfully, the case never gets charged. But what you have now is when you have the DA's office that is always sort of policed its own, and then you have the federal U.S. Attorney's Office that's always handled these kinds of cases. Now you're adding a third level with the Attorney General. It's very difficult as a criminal defense attorney to sort of know who's calling the shots. And if we can convince the U.S. Attorney's Office to not charge a case, do we still have two other offices now? And I think you'll see more of that. This is definitely politically, very, I think, necessary. And I wouldn't be surprised if it goes further. But I think from my perspective, there's already a lot of challenges in terms of defending what these investigations and cases are going to turn into. And I think that going further would only add to those challenges.
And Mari, I actually think that there are some dangers for the prosecutors in having so many jurisdictions involved, because, police officers have guarantee rights, as we talk about, they have some special rights. And if you have some prosecutors rushing out to get statements, that can impair what's going on others. If you have multiple grand juries going on, I certainly hope somebody has a way of coordinating all these investigations to make sure we don't run into those problems.
So Eric, I just want to end with you on this topic, picking up on what Lori said. How do you think this will work, practically speaking, between the DA? I mean, the AG at this point is creating at least 50 new positions just to investigate approximately 40 shooting deaths a year. So how is this going to work, practically speaking?
It's a great question, because generally the Attorney General's office and the District Attorney's office don't coordinate. And, they have their own trial lawyers. In fact, I think there's, right now the Attorney General is, from what I can tell, has one major profile case that I think Michael's firm is handling. I think it's going to be difficult if they're the ones who are actually doing the trial work, because they're not really a trial office, as I'm sure Michael can attest to.
Well, it'll definitely be interesting moving forward to see how this will all play out. I think with all of these different pieces of legislation, because it's new, because these just passed, the real question here is, how is this going to affect prosecutions moving forward? So the next topic we have is Assembly Bill 3070. And I recently wrote an article that's going to be published titled "A Sea Change to Peremptory Challenges," because I think this is just a complete shift in how jury selection process will work. And I just want to say, this isn't going to just affect criminal trials. It will also affect civil trials. It will affect criminal trials first, starting in 2022. So criminal prosecutors have some time to adjust, and then civil attorneys have even longer to adjust, because starting in January of 2026 is when this new law for peremptory challenges will take effect. And what this new law seeks to address is unfair exclusion in the jury selection process. It will limit the removal of prospective jurors without cause or under peremptory challenges. And this is a change that is intended to prevent discrimination based on race, ethnicity, gender identity, sexual orientation, national origin, or religious affiliation. So Eric, I'm going to start with you as a prosecutor, because this new law considers as presumptively invalid a laundry list of reasons for striking a prospective juror. Many reasons that, in my opinion, as a former DA, you would rely on in seeking peremptory challenges. That includes expressing distrust of the criminal justice system, having a negative experience with the justice system, having a close relationship with someone who had been charged with or convicted of a crime. There are other reasons that are also deemed presumptively invalid, like a prospective juror who speaks English as a second language, who provides unintelligent or confused answers, or even a juror who is inattentive or combative during the jury selection process. And for those reasons, that's why the California District Attorneys Association raised concern. They said that this bill is one-sided, that it will punish innocuous conduct, and that it infers ill intent without any basis. So I want to ask you, what is your take on this change to peremptory challenges? And do you agree with some who say that it favors criminal defense attorneys and is designed to ensure that only those jurors who are predisposed to acquit can serve?
So I actually testified in front of the Public Safety Committee on this bill. It is entirely geared against the prosecutor. And it's based on I would think is a flawed study from Berkeley. It was interesting that one of the original opponents of this particular bill was the Association of African American Judges. They wrote a letter of concern to Dr. Weber, who's the author of the bill. Not that everything in the bill was bad, but for example, the unintelligible answers. If someone gives an unintelligible answer, you're supposed to go back and try to rehabilitate that juror. I'm not sure how that juror is going to take it when you're basically saying, your answer doesn't make sense. So, please show us why you're qualified to be on this jury. The difficult part in terms of being a prosecutor, and I was most of my career was in the Compton branch of the DA's office, where I prosecuted gang cases, sex cases, and domestic violence. The difficulty of being a prosecutor is that if one person disagrees with you, it's over. And it's over from the very beginning. No matter what the evidence is, no matter how good the evidence is, you might as well have not wasted 3 to 4 weeks of your jurors' times and the judge's time in giving the case, because it's going to be a hung jury. And one of the things I always found that was success in terms of being successful in terms of picking a jury is that I think the picking a jury is you want people who are invested in the community. And one of the things I always, just in terms of Compton, I always wanted people from Compton or the surrounding community as sitting in that jury pool. And this particular law will make sure that at least there's one person sitting on that jury who's automatically going to be against you. It doesn't matter what neighborhood you're talking about. There's always going to be someone who has a visceral reaction against law enforcement, visceral reaction against you as a person, or the criminal justice system. And there's really no way to kind of get that person off your jury at this point with this law. So I expect a lot of hung juries. I think at this point, the best solution would be if you don't believe in peremptory challenges, if you think that there's some type of hidden bias behind every decision, then just get rid of peremptory challenges and make everything for cause, so that both sides have to articulate a very good reason why that juror should be off the jury pool. One of the, I think, frustrating things about this particular study is it never really addressed the bias that is used by the defense all the time. Somehow, every single one of my cases, almost every Asian is kicked off the jury panel by the defense without them ever speaking to one word to those jurors. They're immediately kicked off. That's because a lot of defense attorneys think Asians are bad on their jurors, so they'll just kick them off. We don't really have any recourse. We could wheeler the person, but it's pretty much useless when we wheeler someone. All that happens is we get a new panel or that juror stays on, but there's no real effect on the defense. There's no kind of, it doesn't really temper the defense in terms of getting rid of jurors for racial bias.
Well, let me just ask a follow-up then. Do you think that under this new law, the defense, you would be able to take advantage of the new law so that it equally applies to both sides, so that if a defense attorney is kicking off the only Asian juror in a panel, then you too should be able to take advantage of it being presumptively invalid, whatever quote unquote race neutral reason they give?
So the race neutral reasons that are given primarily in this, or that are articulated in this law, are reasons that a prosecutor would want someone off their jury. They have a hostility against the justice system. They have a bias against police officers. So none of the reasons really articulated within this law are really against the defense. The law was clearly aimed at prosecutors and no one else.
So Michael, I'm going to ask you something that Eric mentioned. He said, why not just do away with peremptory challenges altogether? And that's actually something that the president of the Alliance of California Judges advocated instead of this bill, and speaking out against the bill. He just said, let's eliminate peremptory challenges altogether. This has been echoed by prosecutors besides Eric, who say that at least that would restore parity between criminal defense attorneys and prosecutors. So would you, as a criminal defense attorney, prefer a jury selection process where there's only for cause challenges and no peremptories?
I would not. I'll start by saying I did agree with Eric's point about the Attorney General's office on our last question, but here I am afraid I have to disagree. I just think that the notion that there needs to be some balancing here for the defense in jury selection is just not the way the system is set up. I mean, it's the prosecution's burden to convince the jurors, and to be honest, the defense has every right to try to have the one juror who just, vehemently has a problem with the system that translates into a problem with the case. I think these concerns are overstated, because I think a lot of these concerns, I've heard it referred to as like the sleeping juror, or the juror who just doesn't believe in the legal system or hates law enforcement. Those are not nuanced views. And I tend to think, at least in my experience, those would probably still be jurors who would be struck for cause without too much difficulty. I had experience as a prosecutor where someone starts explaining, they don't trust law enforcement, and you just sort of, you start to worry, like Eric does, like you may have just already lost your trial. But usually in my experience, if you do further follow up, whether it's from the judge or attorney voir dire, there's usually more nuance to the question, to the answer to that question, why they don't trust law enforcement as a blanket rule. And I think that the peremptory challenge is not so burdensome on the prosecution if they really do feel like, when that nuance is explored, that they still have a valid reason for using a peremptory challenge. I think, first of all, they still have that right. And I don't think it's that difficult for them to be able to explain why they did so. I mean, this concept of a race neutral justification has long been a part of the criminal justice system. And prosecutors have an obligation to do justice, and they know that they need to be prepared. And so when I was a prosecutor, you were obviously always trying to do this fairly and do justice, but you're also cognizant of the fact that you may be challenged, and you have reasons in the back of your head, somewhat drawing on that nuance that I was discussing, to explain, I'm not just striking this person because they're Asian, or I'm not just striking this person because they don't trust the LAPD. There's always got to be some more reason. I don't think it's that difficult a burden to put on the prosecution, considering the overall burden in a criminal case. With respect to getting rid of peremptory challenges, I think it would completely undermine the purpose of this, which is to eliminate some of the bias and disparity in jury selection. As I understand how jury pools are generally put together, they draw primarily on DMV records and voter rolls. And so you've sort of already skewed towards people in society who either own a home or have a more stable residence or have kept their driver's registration, vehicle registration up to date. I tend to think that the people that are captured by that are already excluding the types of people who might be more favorable to the fence and more reflective of the community overall. And so if you do away with peremptories and you're just left with the people who have done their civic duty of responding to their jury summons, I think if anything, that would give you a more biased jury pool in favor of the prosecution. And I think it's already biased that way. And this change to the peremptory system does a good job of rebalancing it in a way that I'm very comfortable with as a defense attorney. And I think that the proposed alternative would just undermine the whole purpose of this reform, which is a good one.
Now, Mike, I'm going to pick up on something that you said at the end and get Lori's take on this. You said that the way that they pool jurors now from voter records, DMV records, is something that leads to prosecution-friendly jurors. So, Lori, is there a way that we can pool jurors that may be more representative?
Yeah, there are. There are additional ways to get people's records. How about just phone records? Everybody has a cell phone. This, you know, people who get their cell phone registration, or just broader groups. I mean, I do think that there is a need to expand the jury pool in reaction to the discussion that I'm hearing. You know, first of all, there were numbers that drove this legislation. I'm not going to defend either the Berkeley study or the law itself as proposed. But the problem was there. And the problem that the Berkeley study identified for folks is that prosecutors used their strikes to remove Black jurors in nearly 75% of cases, and Hispanic jurors in 28%. Now, the appellate courts very rarely would overturn that, which either means that prosecutors hadn't done anything wrong, or the record wasn't clear enough, or we all just think that there's enough of a reason for all those particular people of color to have been excused. But it does raise a question about whether it's fair, and also whether judges and how they're interpreting a neutral reason is something that has to be examined. I think the purpose of the law, frankly, maybe would have been better accomplished in getting judges who are more in tune to the whole issue of unconscious bias. That is real. And it was actually, you know, I bring him to all my classes, so I'll bring him to this discussion. This guy, Thurgood Marshall, in the Batson case himself, who sort of said, this system will never work, because unless we're honest, whether we're in touch, whether we realize unconscious bias, there's going to be a bias in it. I still don't think it'll work to eliminate peremptory challenges, because you still have the bias by judges as to whether it's a challenge for cause. So in some ways, I've got to defer to the lawyers right there in the court. And I think Mike's right in that, Michael's right, that it's pretty tough already. The jurors are going to come in. If you want to ask me, in addition to expanding the jury pool, and there are additional ways to do that, other sites that they can use, I think it's always been a bit of a disservice how much the judges have cut back on voir dire. You know, let the lawyers who know their case, know their witnesses, know the problems that's coming up in the case, know how people have reacted to them. Give them a chance to actually have a conversation with some of these jurors, and not just to argue their case. We all know you're going to try to do that, cut that off, right? But to find out more about what about their role in the community? What has it been in the community that has alienated them? And you may have to do this outside the presence of other jurors, and sure, it'll take longer. But ultimately, I think that gets us to more the jurors' attitudes and less sort of the optics of who we're kicking off jurors.
So, Michael, I'm going to end with you on that, just what Lori said. Do you think this will end up in a longer process, a longer voir dire, jury questionnaires, which I'm in favor of jury questionnaires? I don't know how you feel, especially if we're trying to come up with race neutral reasons and justify the reasons why we kicked off the juror or wanted to kick off the juror, and explain that it's not because of these presumptively invalid reasons, it's because of all of these other reasons. And you need time to spend with these jurors and to get insight into the way they think and how they feel. So do you think this will lead to more time in jury selection? And do you think that's a good thing?
I think it will, and I do think it's probably a good thing. I mean, it goes back to my earlier point about a lot of times there's a nuance that's underlying what seems to be sort of a blanket, hard-headed response. And I don't know about how many members of the audience have ever made it, very far into jury selection. They always try to strike lawyers. I've had the experience when I was a prosecutor of being 2 days of jury selection. And it was a very educational experience because even for someone like myself, it's an overwhelming process. And if you've never been in a courtroom and or let's say you've been in a courtroom and it's been a negative experience, or you have some family who was, there's so many layers of human emotion that need to be picked through. And oftentimes when voir dire is cut very short, or the judge just reads a standard question like pro or con law enforcement, people are so overwhelmed that their knee-jerk reaction is oftentimes completely unconnected to the realities of the case, which the judge may not know very much about. And so I totally agree with Lori's point that the lawyers know the case and they know the issues, and let them try to get the jurors comfortable enough. And it takes some time, I think, for the jurors to get comfortable enough to start thinking, all right, here is my general view of law enforcement, if you ask me. But when you start telling me a little bit about the case, right, to my earlier point, what if law enforcement's the defendant in the case? Then how do you feel? These are important points. It's very case specific. And so I think it will definitely take more time, and I'm sure that'll be frustrating for defense attorneys and prosecutors alike, but I don't know that that's what this process is about. Trials take time, right? I mean, this notion that I keep coming back to of getting to the nuance is really the whole point of the trial. And so if you're saying that it takes more time to get to people's real views during jury selection, well, then that's good. That's what you should be doing in a courtroom in the first place.
And Maury, I'm just going to jump in and say, I've sat on juries, but here's the surprising part, where both the prosecutor and the defense lawyer were my former students. So then you see things from a whole new, yes, it's true. And nobody wanted to kick me. I guess they thought I was equally unfair. But I do think that we have people making these decisions who haven't necessarily sat as jurors. And that is a very eye-opening experience.
One of the things that I thought was interesting in terms of both speakers talked about expanding the jury pool. The only way you're really going to expand the jury pool in terms of people who actually want to serve on the jury, who are actually there, and who don't try to get off, is if you increase how much they're paid per day. It's extremely difficult for low-income people to be able to sit on a jury when you're making $12 or $18 a day, plus 50 cents for mileage. It's an incredibly burdensome thing for low-income people to do. So if you want to increase the pool, increase the daily stipend. That's probably the most effective way. When I brought that up to the Public Safety Committee, they were not, that was not a big, it was not very popular with them, because the state government just does not want to have to pay the extra money.
Well, certainly there could be a lot more legislation that comes out in the coming years, all with the same aim of trying to make the jury selection process more fair, because obviously, while this law may do its sum, it doesn't go all the way. So the last topic we'll probably be able to get to is, I know it's a piece of legislation that is close to Lori's heart, Assembly Bill 2542, called the California Racial Justice Act. It prohibits prosecutors from seeking, obtaining, or imposing a conviction or sentence on the basis of race by expanding the opportunities for defendants to challenge racial bias in their case. Under the new law, defendants can file a motion in a trial court or a petition for a writ of habeas corpus and attempt to vacate their conviction or their sentence if they prove by a preponderance of the evidence that an attorney, a law enforcement officer, a juror, the judge, or an expert witness exhibited bias or used discriminatory language about their race, ethnicity, or national origin. So, Lori, I'm going to start with you. This new law makes it possible for a person who is charged with or convicted of a crime to challenge their conviction or their sentence by showing that there is statistical evidence that people of one race are disproportionately charged or convicted of a specific crime or enhancement, or that people of one race receive longer or more severe sentences. But this new measure is directly contradictory to a 1987 US Supreme Court case, McCleskey versus Kemp, which held that statistical data showing evidence of systemic racial discrimination did not constitute sufficient evidence to overturn a death sentence. And instead, the court held that to successfully challenge a conviction or a sentence based on racial discrimination, a defendant would have to show specific evidence of racist motivation or intent in the prosecution of their individual case. So how is it that this California law can go against US Supreme Court precedent, and do you think that other states will follow suit?
Okay, so here's a shocker. I think McCleskey was wrongly decided, folks. And I think that what we've seen, the death penalty is the real extreme area, but there are a lot of cases beyond that where there has been racial discrimination. And as you said, it's near to my heart. It is near to my heart because I handle post-conviction, wrongful conviction cases. And we're looking at cases 20, 30 years ago. I certainly hope, although Michael will tell me whether it's a more enlightened system now, but there's unquestionably racial bias that went on and led to people getting harsher sentences, being charged more, being treated as the other in our criminal justice system. And we have a chance to do something about it. Now, the new district attorney has actually made this a factor in his new conviction review integrity unit and his habeas unit, just to keep race in mind. And we have a case right now, we have many, but it's not unusual for our client to have been the only person of color in Compton, by the way, when they get convicted. So everybody else was white. The prosecutors were white, the judge was white, the jurors were all white, even as their own lawyer was white, the officers were white, and you have the sole defendant. And then you read through the transcript and you just hear the nature of the discussion, the nature of the assumptions about those people. And we have a chance to sort of change the whole narrative there. So I'm not saying that in every case that it's automatically going to be enough. And I don't think our judges would buy into that. They've been in the old system for quite a long time. But I am in favor of us sort of being more open to what the issue of race, how it plays a role actually in a case. Because cases, as these very experienced lawyers know, and as you know, are based upon eyewitnesses' IDs. Are those tainted by race? Oh yeah. Statements, can they be, interrogation be tainted? Oh yeah. Pretty much everything we've been relying on in the system can be impacted by race. And the question is, how good are we at ferreting out and preventing it in the future?
Now, before I turn to Eric, because I certainly want to get his take on everything you just said, Lori, you mentioned the DA, the new DA, and what he's doing in terms of the conviction review unit and the Hablet unit and how this will be handled. Can you speak a little bit more about that?
Yes, well, he's asking his lawyers when they review cases to always do so, quote, in the interest of justice. And he has articulated various issues that may address that, including the issue of race. And so he sort of brought that out. It's not the only factor, but it is a factor to sort of address front and center, because I think everyone was too afraid to talk about it. I think everyone sort of was taking it personally. Oh my God, I'm not a racist, nor possibly could be the person who trained me in this job, nor possibly the DA who tried that case and became a judge. And I think the answer is, let's stop making it so personal and take a look at the reality of how race has affected cases.
Eric, I see you nodding at the end there, so I want to ask your opinion, what you think Lori said.
Well, I think that I think there is this issue of implicit bias. And I think that one of the things that we kind of have to, as a system, kind of have to ferret out is when that's rearing its head. I don't think it's, I don't think it's personal. I think there's a lot of people who may think that they're acting in a race neutral way when they're actually not. One of the things that our former DA did was, she instituted a policy on training on implicit bias. I actually thought it was a very helpful and useful training seminar that we had to do. But I also think that it's very dangerous, and that's, especially when you have Supreme Court decisions and you also have your state bar ethics rules prohibiting you to really focus in on a person's race as a determining factor in what you're going to do. So it's, I think there is that issue as well that's kind of pulling against it, and that you can't just look at the statistics of who's convicted and make a blanket assumption about what that means. I think the U.S. Department of Justice recently did a study that kind of debunked a lot of those issues, that people were being arrested at a higher percentage because of their race. And this is not, it wasn't some political hack in the Department of Justice under Trump. It was a statistician who actually knew what he was talking about and did some rigorous analysis using data. So, I'm not sure that just blindly looking at numbers without understanding what those numbers mean will actually get some type of result. Again, going back to that Berkeley study, which talked about the prosecutors kicking off African Americans within the 70% percentile in terms of jurors. Those cases, I think it was like 680 cases that it examined. During that same time period, there were 110,000 trials. And so they're looking at a very small data set. And I think one of the problems that we have right now in terms of having an honest, good discussion about race is that we are especially within the criminal justice system, especially when it comes to courts, we're really bad at collecting data. We're not really a data-driven profession. So I'm not sure how we're supposed to use data when we're not collecting data either.
Well, in talking about data, Michael, I want to ask you about some data that the person who sponsored the bill relied on in saying this is why it's necessary. It was a former public defender. He said the law is necessary because the U.S. Supreme Court case that Lori so despises insulated racial disparities from judicial review. He said that this bill aims to fix the racial disparities that exist when you look at those that are prosecuted and those that are sent away to prison. And he cited a 2016 report by the Sentencing Project that California has one of the highest sentencing disparities in the country, incarcerating Black men at over 8 times the rate of white men. So do you think that this new law will be able to close that gap?
I think that's too big of a gap to close by any one bill, but I think it's definitely a step in the right direction. And I can't remember which two states, but I think it was, I want to say North Carolina and possibly Florida that years ago came up with some sort of workaround to McCleskey. And then I think one of them rescinded it. And if it's not those two, they're definitely close neighbors. And so the idea that California is only now getting up to speed with those states, I think is, too little, too late. But to Eric's point, I mean, these are difficult issues to figure out. And I think the statistical analysis is one front. And I think, like Lori's mentioned, just sort of having prosecutors who think about this a little bit more, those are both steps in the right direction. And I think if you then give defense lawyers, either during trial or post-trial, like Lori's project, I think that will make up some of the gap. I hope this gives you an opening to try to make up some of that gap. I know from my experience in the U.S. Attorney's Office here in LA, is only recently, but it's a step in the right direction also, started to do more formal training on implicit bias and thinking about, it's not just how many defendants of this color or not are we charging. It's what kind of cases are we charging against different communities, what sentencing approaches are we taking once we file those cases? What kind of cases are we not filing? And every step in between. And I think, unfortunately, it seems to me that a lot of the hard work in this area comes post-conviction, where these injustices have already been perpetuated. And it's so much harder, as our panelists know, to undo it once it's been done. This hopefully gives some more ammunition in that fight. But if it makes people think even just a little bit more about it during the process, then hopefully, it can cure some of that on the front end. And even if it's not the perfect cure, I definitely think it's a great step in the right direction.
And I'm going to end with Lori. I want to ask you, because you are in favor of this bill, there is a limitation because it will only apply prospectively to criminal cases in which the trial court judgment is issued on or after January 1st, 2021. Do you think that this bill should have done more and also applied retroactively?
Well, I think it's not easy to get these bills through. And so what we have to rely upon, again, are prosecutors who have issued directives sort of saying, even though the bill doesn't require, this is what I think makes sense to take a look at. And, the good faith of everybody in the system has always been the most important thing. You can pass laws up and down, but unless the lawyers want to do the right thing, it's not going to happen. So I'm really grateful for the lawyers in there who say, I take this seriously, regardless if the bill covers my case or not.
Well, certainly it'll be something that we watch over the coming years. Since we have a minute or two, Eric, I'm just going to ask you finally, practically speaking, how you think this new law will be implemented.
I hope that it's taken in the way that Lori and Michael talk about, which is kind of something, to highlight this issue, to make sure that everyone is behaving appropriately, and also to make sure that everyone is thinking about what, whether they're really acting because of what the evidence is suggesting or telling them, or whether they're somehow behaving because of some type of implicit bias. So I'm hoping that's how people look at it, because I think that's, one of the things I remember from the training that we had was this video that kind of showed the behavior of two types of people that were walking through the park, and how they acted between someone who was black and someone who was white. And I think it's important that we always kind of keep that in the back of our mind. Are we asking for these sentences? Are we charging these people simply because of some assumption that is working in the back of our head? And so I don't have a major issue with this law. I think it's good to keep that in the back of our head, or actually not even in the back of our head, right in the forefront, so that we're making sure that we're honoring the system and honoring the process.
Well, Lori, Eric, and Michael, I want to thank you all for joining me and joining all of us tonight. I think this was a very interesting discussion. I could have gone on and asked all three of you about all of the laws. In fact, there was a fourth we didn't get to. So we'll have to do a 2.0 on legislative reform in the criminal justice system. But thank you all for a very interesting debate tonight.
Thank you. Thank you.
Thanks very much.
Take care. Good night.
Good night.
Good night.